Good day, everyone. Thank you for standing by. Welcome to the Alston and Bird Navigating the California Consumer Privacy Act webinar. Key issues in operationalizing with the new requirements of the CCPA conference call. Today's conference is being recorded. At this time, I'd like to turn the conference over to David Keating. Please go ahead.
Thank you. Good afternoon and good morning to those attendees on the West Coast. This is David Keating, and I would like to welcome you to our latest program on the CCPA. Today we're going to be focusing on key issues in operationalizing the requirements of the statute, and we thought that the timing was right and good now to zero in on particular areas that are of challenge to our clients, either because we have certain gray areas in the statute, of which there are many, or because we're not yet seeing common practices develop in the market, and instead we're looking for ways to address certain requirements consistent with what we anticipate will become and would project to become more of best practice standards. It's certainly not unusual and looking at privacy law over many years for there to be a certain amount of uncertainty in the work that we do. We are used to, as privacy practitioners, dealing with gray areas and dealing with situations where we have to quantify risk, make decisions in the real world, because there are perhaps no perfect choices in many of the things that we do. And a lot of that, too, I believe, is because of the inherent nature of this intangible asset that we are working to manage. But California presents us a uniquely uncertain environment currently. We had the statute itself enacted about a year ago, almost a year ago today. There were problems noted right away in the drafting of the new law. Some of those were addressed through amendments that we saw come into effect around Labor Day of last year. But now we have a series of new amendments that are working their way through the legislature. A number have cleared the Assembly in this session and are now before the Senate. And many of these amendments are material. They're significant. They're going to change, for example, if they go through the scope of data that's regulated by the new law, how we define de-identified information under the statute. That's happening while we still are only now 6 months away from the operative date of the statute. At the same time, the California Attorney General's Office is engaged in its rulemaking process. We expect to see a draft set of proposed regulations in the fall, which will kick off the comment period. And if you think it's a little unusual for the regulator to be drafting the regulations while the law is in the course of being significantly amended, you're right. It is unusual, and it remains to be seen how the timing of these amendments will impact potentially the timing of the rulemaking process, which could potentially impact timing of the effective date of the statute or even the enforcement date of the new law. At the same time, states are starting to act. We've been watching a number of jurisdictions for some time. Of course, Washington received a lot of press for its work toward a statute that did not come to pass, at least in this session. But then Nevada just recently moved about 2 weeks ago and established a new right to opt out from data sales. Narrower scope than what we see in the CCPA, but emphasizing the need, we think, to be thinking of California as setting a more national baseline for our operations. While we have this backdrop of uncertainty, there are some big things that we know we need to do regardless of what happens in California in the legislative process and regardless of what happens in other states. We know that we need to be inventorying our data assets. We need to do that as privacy practitioners so that we understand better the asset class that we're managing within our organizations, so we're better able to help manage risk, so we're better able to enable, which is, of course, a key part of the job of the privacy practitioner as a steward of data. But we also need a data inventory, and we need to understand our data assets so that we can properly and in an accurate way fulfill rights requests that are submitted by individuals and ensure that we're doing so in a way that will be compliant, and also will be consistent with how we want to be interacting with our customers and with the market. We also know that we need to inventory data sharing arrangements to understand where we are sharing information in a way that provides the recipient of the data to use the data onward for its own purposes, and to do that so that we can, again, fulfill these new rights that we're seeing in California and Nevada, but also so that we can fulfill this concept of consumer choice. And we know, too, that we need to be prepared from a procedural standpoint and from a technical standpoint to fulfill rights requests from individuals, whether that's because the law tells us we need to do it or because we feel that it's how we want to be conducting ourselves from a brand perspective. And it's these things and these topics that will be a part of our focus in our discussion today. I'd like to introduce our speakers. We have two of our new partners who joined us in the last year who are presenting with us today. Amy Mouchouar joined us this spring from Davis Rights for Maine. And Amy, I always mention first, not just an attorney, but has a deep technical background as a former technology consultant who actually started her own technology consultancy and also served as the Chief Information Security Officer in the past for another organization. So she's the real deal when it comes to these technical issues, and it's been awesome to add her to our team. Her practice is in the area of data security, cybersecurity, data breach incident response, and consumer privacy advisory work, including with the CCPA. Also today, we'll hear from Larry Sommerfeld, who joined us last summer from the Department of Justice, where Larry was leading the Computer Crime and Intellectual Property Unit of the U.S. Attorney's Office in Atlanta. He was also a part of the Department of Justice's Computer Hacking and Intellectual Property Working Group. And before joining the U.S. Attorney's Office, he was a technology lawyer in Silicon Valley, and his background and his presence has been an awesome add to our team as well. A quick overview of our agenda. We're going to talk about some insights we've developed in connection with data inventory and data mapping work. We'll discuss cybersecurity in the CCPA, not to be forgotten as we think about all of the new privacy standards that we're confronted with. We'll discuss vendor management, and then a couple of specific issues that we are seeing some standards potentially form around, or at least where we have some thoughts about how we should address some new requirements. And then time permitting, we'll have some Q&A at the end of the presentation. We encourage folks to send in questions through the webinar interface, and we'll be monitoring that interface to try to respond during the program. And if we don't get to your question during our session, we will follow up with you afterwards. A couple of administrative points. We are offering CLE credit, and at the end of the program, we're holding it back for New York attendees. We'll have a code for New York attendees to use. We will also distribute the slides from today's program to audience members. And as noted, we are recording the session, and the recording, too, will be available on alstonprivacy.com. So I'd like to go ahead and hand off the baton to Larry to talk to us about data inventory and data mapping.
Thanks, David, and good morning and good afternoon, everyone. It seemed a good place to start because for many organizations, the place to start when operationalizing the new requirements of the California Act is making a data inventory and data map. So we thought we'd start there today. And just to bring us all to the same place to start, you may hear these terms, data mapping, data inventory, thrown around a lot. And your organization may even be in the middle of mapping its data. But it makes sense to start out with first principles and discuss what we're talking about. Let's define, for purposes of our discussion today, what is a data inventory or a data map. And a data map in particular, that term can have different meanings in different contexts and can be used formally in computer science, for example. But for our purposes, we'll be using these terms, data inventory or data map, less formally. But it's something that tells you what information your organization is collecting, where that information flows within and outside of your organization, and sets forth the basis for collecting and using and sharing that data. So it comprehensively walks through the data life cycle at your organization. And it shows where your data moves. And often these are called information flows, and shows potentially unforeseen or unintended uses of data, which, as we know, will be critical under the California Act. It includes an inventory of systems in your organization that have or use personal information. All this actually might sound simple, or maybe it doesn't, but even if it sounds simple, we know that what sounds simple in theory is often more difficult and complex when it comes down to it in practice. So that's what a data map is, but it's a fair question to ask, why are we going through the trouble of making one? You know, the GDPR, when we went through that, had accountability standards and expectations. If you look closely at the California Act itself, it says nothing specifically about having a data map. Well, to understand why it's a good starting point and why we're talking about it today, it's best to start with what the purpose is. And so the California Consumer Privacy Act is all about the sale of data, but you're going to need to know what data do you sell, and that starts with what data do you have, and asking the question if that data is shared with others, which of that data is shared. And then you have to determine, are those sales, and do those sales have a legal basis, whether that's consent or another legal basis. In order to comply with the Act, your organization is going to have to know how to, whether it's using the personal data or how it's using that personal data. And is that data only being used as authorized or agreed to by the data subject? So the point is to become aware when the organization's use of the data exceeds that scope. And the data map or the data inventory is going to help give you that knowledge. It might tell you that your organization needs to update your privacy policy or ask for further consent to use the data the way you are using it or intended to use it. And it's going to help inform you of what you can do to honor a request to opt out of certain uses of data. Now, one aspect of the CCPA, which has gotten a lot of note, of course, is data subject requests, and that's new for the United States. And data maps and data inventories are going to help your organization answer the question of how it can timely respond to those requests. So if a California resident asks, what data of mine do you have, or to provide that data to them or to somebody else, another company in a portable format, you're going to want to know what data you have and what format that data is in. Or if the California resident asks to be forgotten on your systems, please delete my data. If you are going to be handling those individually, ad hoc, and going searching for those data, it's going to be a lot of time and a lot of resources and a lot of unnecessary costs. But if you have a data map, it can help you do that systematically. Now, you're going to get 45 days at least to do this. And I was just talking with David yesterday about how long an extension
45,
is.
90, 135, 180, we're not quite sure.
We're not quite sure. But we do know that if the organization can build a compliance rights fulfillment mechanism and process, a system, so that when they get a request, they know they do whatever that process is. And if they can do it in such a way that the workflow is automated, that it shoots out requests to data owners who need to respond and then do so, optimally within the 45 days that we know is the initial period, that's going to lower the cost to the organization in terms of time and effort and resources. And they'll be able to systematically handle these at the lowest cost possible. And so that's part of why we're doing this data inventory and data map, to set up the systems that are going to be required to handle these sort of requests. There's another question which data maps help answer, which is becoming more important, and that is what data was compromised in a data breach. We're seeing the time frames to notify individuals, but also notify regulators after a data breach shortened considerably. We know in the GDPR it was 72 hours, New York Department of Financial Services at 72 hours. And a data map might not provide a perfect answer to this question, but the regulators expect that you're going to be able to tell them, if you know what system was compromised, you should know what data was on that system. And so a data map can help you deal with the quickening response times that are in our breach notification statutes and regulations. And data maps answer some important internal control questions, such as who has access to personal data, and who's accountable for that personal data, and who's accountable for that personal data, how it's being used, and who that data is being transferred to. And again, as regulators become increasingly focused on privacy, it becomes incumbent on all of us to be able to answer these questions in a timely fashion. And we'll know that from our data inventories and data maps that they're done well. So overall, this concept, it helps you answer the question of whether there are appropriate technical and organizational safeguards to make sure the data that you have is being used properly. So you may be asking, and it's a fair question, haven't we been here before? There are a number of you, your organizations invested in making data maps and data inventories under the GDPR. And that's terrific, and you've been through the process, you have the work product in hand, and you may be asking, well, that's great for everybody else, but we've already done this, so am I done? And the answer is you are certainly farther along the road, but you might not be through quite yet, and you probably aren't through quite yet. And that's because there are a couple of differences here. First of all, there's a different geographical scope, obviously. Of course, the GDPR concerned with what data was processed in the European Economic Area, what data flows to and from the EEA, and it concerned data subjects residing in the EEA. And now we're talking about California, and if other states follow, any number of other jurisdictions. So, of course, you want to check and see and validate that your data maps include the data from these other geographical areas, these other residents. And second of all, there's a difference in scope. There are different provisions. Again, we talked about how the California Act is focused on sales, and that's different than the GDPR. So you're going to need to tailor your inquiries to this separate act. You need to respect that this is a different piece of legislation with different specifics and different emphasis. And so a comprehensive data map throughout the organization that's already made, perhaps through the GDPR, maybe cover a lot. Maybe if you're fortunate, it covers everything that's needed under the CCPA. But it's likely there's going to be need for some additional scope and questions to inquire about. And you're going to want to confirm and validate that you have the information you need geographically and in terms of subject matter. And you also want to make sure that you capture local systems. Lots of times, organizations included enterprise systems in their previous analysis, but that may have left potential gaps in their data inventory.
That, I think, is key too, right, Larry, as we think about how organizations are attacking the data inventory perspective if they have built out registries or databases for their GDPR programs, because it may be, to your point, that there are local activities in California or in other jurisdictions that were not covered, right? So I think that's the point of emphasis, to make sure that we're not taking that reflexive assumption that we've got it all covered, but that we do think about local California activities as well as needed.
Absolutely, absolutely. Now that we've talked about the purpose of the data map and what it is, it makes sense to talk about what tools we're going to use and what methods we can use to make our data map and data inventory. And one way to think about the project is to break it down into 3 categories or steps. First of all, data inventory. We've been using that term. What data do we have? What systems do we have? Data flow. Where does that data go within and outside the organization? And then a data audit. How is the data used? And what is the legal basis for that use, for the collection, for the transfer? And we're going to want to do that. And that's one way of thinking of the project. And another way of thinking about it is to think about the fact that you're going to need a map of your business process, your different processes that you use to conduct your business, and the personal data that are part of those processes. And then you're going to want a map of your IT process and systems, because the business process may be what we think of, how we think we're using our data. But really, the IT process may let us know how we're actually keeping and using and transferring that data.
Yeah.
So
And
there's several ways of...
Larry, if I may there too as well, and you brought up earlier that, of course, it will save time if you have an understanding of your IT systems flow. But, as a line engineer, when you have an alert coming in regarding a system, if you have your systems mapped, that engineer can functionally understand what that system does to help prioritize getting a lawyer involved earlier, assembling an investigation team earlier, so you can protect privilege earlier, which will be all the more important given that we're entering in a greater potential for class action litigation with statutory damages under the CCPA. So, in addition to just making things quicker, having IT maps and data flow maps can make you have a greater potential to protect your company.
Great point.
It's an excellent point, and so that needs to be kept in mind throughout as well. So there are several ways of creating a data map, and it depends on the rigor you want, the end product you want, and these are different approaches have different costs. So just in terms of examples, you can hire consultants to do it, and some consultants are better than others, but this is the most rigorous way of doing it, and you can get an excellent end product from them. You can use a tool to help you create the map, and there's a number of automated tools out there, workflows and questionnaires that auto-populate a pre-formulated map, and these can be very good. But we will give a warning here that you want to be aware of just using questionnaires, because employees may be answering in good faith, but without being able to understand the context, their answers might not give you the information you need. So you likely need follow-up interviews beyond just simply sending out questionnaires. And there could be more automated ways of doing this as well. And then there's also do-it-yourself, where you design a bunch of interviews and working sessions with follow-ups, and you make maybe an Excel table as a mapping database, and you do a self-made questionnaire and you follow up. It's a mistake to think that IT is going to do this on its own. We're going to talk more about how this is more of a holistic process. And so as we talk about some of those ways of doing it, one of the reasons we're all here is to talk about common observations and issues and how to solve the problems that we're seeing. And so we want to give you some information that's helpful in solving those issues. So the first key issue is ownership. You really need executive buy-in and real resources, privacy and technical resources, to make a functional and useful data map, data inventory. You're just going to need that backing. And one way of thinking about this is to turn it around, that this is really an opportunity. It's time to get your arms around your data resources, your data footprint. And this is an opportunity to get business support for managing your data assets, right? We have this act, we have to comply with it, and it gives you an opportunity to make the business case that we're going to have to get our arms around the data assets, and we need some hands on deck to do this. Now, one of the concerns we talked about it earlier is you want to capture what actually happens versus what happens in theory. And so let's talk about some more concrete and practical concerns. First of all, it's best to try in advance to identify what you'd like the end product to look like, even before you begin. It helps you determine how you're going to do it, and it helps you determine the content of those interviews, the content of those spreadsheets. You want to picture what you're going to end up with before you start. And for many, that Excel spreadsheet's going to be fine. You're going to have columns that you know you need to execute a data request or that must be disclosed on the privacy notice. But you also want to be aware that simply adding more columns doesn't get you necessarily more useful information. You could also do flowchart and data architecture type diagrams, and some software tools help you do that. If you're going to do that yourself, you probably want to engage IT who might help you do that. But lots of times, spreadsheets are what we need here. Of nuts and bolts advice, when you start going out there and it's questionnaires and interviews, start with friendly departments. It's going to generate some good buzz. You want to generate good buzz rather than stoke any fears or concerns. So choose a couple of departments that you think would be more amenable to this. And you have to know going in that it's an iterative process, okay? You should expect that there's going to be a fair amount of looping back after learning more information and learning how that information is used and how it's stored. And the company's data is going to extend more broadly than you might have originally thought. It's not just IT. It can involve HR, marketing, sales, procurement, digital, social media, website, mobile, and you have to map all your vendors that give and receive data. So these are some of the concerns that you're going to want to deal with. And you might also want to deal with unstructured data that might just be on your company's work laptops or an Outlook attachment. Another nuts and bolts piece of advice here is to be prepared as you start this process to deal with a lot of questions like, will we have to delete this data? People are concerned out there. Will we have to delete contracts? They don't know what this act says. We are still learning what this act says. And when there are questions in an organization, there's going to be natural concern. When it comes to the right to be forgotten or the need for portable data, you might have questions like, are we going to have to hand over our sensitive data to someone? Are we going to have to stop doing business with somebody else? So respect that people may be worried. And it's going to be half talking about data flows when you start and half putting people at ease and letting them know that you're not there to disrupt the business. That's a good bit of hand-holding. And somewhere along the process, worry will get less and disappear. And so at the end of the day, you're going to have a piece of work project. You might find IT loves it. They have something which helps them. And hopefully you have what you need. And after all that, you might ask, well, is this over? And there's a little bit of bad news here, and that is it's really not. Because if you take this on as a project and think, okay, now we have a work product, we're done, we have our data map, that data map will be out of date before you know it. It will be out of date as soon as you get the next IT upgrade or new IT system. It will be out of date when you next expand your business or do business a different way. So it must evolve, just like your IT evolves, just like your business evolves. And you want to have in place a sustainable process, both technologically and economically. If it's only in this year's budget, what happens next year when you do that upgrade? You want to set in place a system that notifies you of anything new that's coming along and also sets up periodic reviews so that you get the most from your investment of time, of energy, of this concern amongst your workforce. And you have something that helps you with your data now and going into the future, whatever the future might bring.
Great. Larry, thank you. We want to go ahead, keep our eye on the clock, too, and move to our next topic. Amy, you want to talk to us about cybersecurity and the statute?
Absolutely, and thank you so much, David and Larry. Just to close out the topic, though, of data mapping and how do I quite possibly keep this monstrosity up to date, one tip is that some of my clients actually attach amendments to the data map to their project management and their IT change management processes. So if you embed it in your workflow that's pre-existing that your business uses, you're more likely to keep those maps up to date. And you might receive comments regarding how on earth can I create a server-by-server data map? We've got Docker services that reconstitute themselves. We have on-demand services and platforms that build and tear down as demand fluctuates. Those are issues that you can readily deal with in the data mapping process. So I would urge you to, reach out in the event of those issues, but don't allow the literal terror of data mapping to overwhelm the process, because it's quite valuable for cybersecurity as a CCPA. One thing that we can tell you with, and if we'll go on to the next slide, with cybersecurity, is we've learned a great deal of lessons from the GDPR experiment. And in GDPR, we learned while folks are heavily focused on privacy, it was security matters that really, now overwhelm many organizations that have to report within 72 hours. They're reporting a lot more than what they normally would, and there's even some data protection officers that are getting overwhelmed with all of these requests. And in the GDPR process, when folks were, operationalizing what GDPR meant to an organization, quite often the conversation would be rather short. Are you following a pre-existing audit standard? Does security and IT generally have this covered? we're going to encourage a much more rigorous examination for the CCPA for a number of reasons. The first of which being consumers have the right to bring private rights of action for personal information subject to unauthorized access, exfiltration, theft, or disclosure. Those private rights of action can be between $100 to $750 of statutory damages per violation. And you could easily have 1 million California residents within one database. So violations can add up quite quickly. And the PI definition, instead of the very broad and robust definition that David had mentioned a moment ago at the top of the program, for security, the definition is pulled from the existing data breach disclosure law. So the definition, of, name, social security number, and name plus that we already know from the pre-existing California statute. In order to have a class action under a data breach, the breach must arise from the failure to implement and maintain reasonable security. Now, in 2016, then AG, now Senator Kamala Harris, drafted a data breach report out of the state DOJ's office and identified that the SANS CIS Top 20 is what is considered reasonable and appropriate in California. It is important to note that many organizations, many benchmark themselves against SANS CIS among several other standards. But what we would want organizations to do is, know what audit standards you're choosing to benchmark yourself up against. Do those necessary security crosswalks such that you know where you're deviating from SANS CIS and you're doing a risk exceptions process. And most importantly, that SANS CIS standard, if you just follow the top 5 security controls that are listed within the SANS CIS standards, it helps mitigate 80% of the universe of risk within an IT organization. And the SANS CIS is actually prioritized based on the issues that cause vulnerabilities and ultimately breaches. So I happen to think the SANS CIS tool is wonderful and valuable for lawyers to know about, just simply because it puts security controls in context with security risk. And we are now trying to, and have for the past 10 years, trying to marry security compliance with actual security risk. One of the reasons why it is very important to make sure that as an organization you're not just checking an audit standard and walking away is because audit standards are quite typically verified by simple interviews. And security is an area where discernible artifacts of compliance do exist, and it can be readily apparent that a company does or does not follow its policies or practice reasonable security. We've learned in a number of state regulatory oversight hearings and FTC CIDs and other examinations that we've been a part of, a regulator may ask for your vulnerability scans. There's not a company that doesn't have vulnerability scans that have significant deviations from normal because of the way that your company operates. And quite often, these vulnerability scans, Qualys, Nessus, HP, there's a wide variety of them, will often benchmark against pre-existing templates or SANS CIS templates that your organization cannot meet in its entirety. If the first time legal is looking at your vulnerability scans is just opening up what will be presented to the regulator and then seeing a number of vulnerabilities that are past your 30-day benchmarking for patching, that seems categorically unreasonable. but it may not be unreasonable if your IT organization has documented all of those deviations from normal. And what systems are internal to the organization, what systems are within the DMZ as an organization. So you know that if you do have a regulatory examination, discovery, and litigation, you can not only show your vulnerability scans are compliant, but if you have critical errors that are not yet resolved, you can show that a risk assessment has been done and those deviations from normal are justified. Your regulators might also ask for your risk register or all of the different exceptions that IT has to make to security policy. If a regulator doesn't see that a risk register, sometimes it'll be called a POAM, and those do not exist, that's a potential indication that perhaps the security within an organization is not yet fully implemented. IT alerting. It is very, very important. Many of your organizations are inundated with IT alerts, that you have sufficient staffing over your IT alerts and that you have them sufficiently tuned such that your organization is listening to the appropriate level of alerting to actually be able to address it. And if staffing and tuning are not within the expertise of your organization, we would highly recommend that you outsource that function to a security MSSP that has the ability to do that. And also logs. It will be readily apparent when you have a breach if you are missing significant log sets. So we want to make sure that in addition to saying you're abiding by a security breach standard or security audit standard, you are actually within legal checking that typical regulatory artifacts of compliance for security are indeed present and robust within your organization. Because unfortunately, with the statutory damages that will arise under this statute, the costs really are too high, and you want to be able to demonstrate as an organization that you're acting reasonably. And if we can we'll go to the next slide. Now, hand in hand with cybersecurity and privacy for that matter is always vendor management. And why do we care about vendors? Most of us conduct a great proportion of our business as vendors or working through vendors. And many companies are sandwiched in between, where you are both a B2B vendor service provider to others, and you implement a number of your processes through vendors in order to provide services to clients. Under the CCPA, unlike the GDPR that has the controller and processor scheme to kind of identify the first-party owner of data and then the second-party vendor, CCPA has businesses and service providers. The definition of a service provider, that is essentially a vendor, is very, very important, and we'll talk about what qualifies you under that definition in a moment. But it's important because there are liability exclusions for service providers, and they're not liable for CCPA violations where they don't have actual knowledge of violations to the extent that they meet the service provider standards. And likewise, companies have liability exclusions for the acts of their service providers given that if they're meeting the exceptions under the CCPA. So it's very important for you to have a handle of them. So what is a service provider? How does a business qualify as a service provider? First, you must process personal information on behalf of a business, and you must be bound by a written contract with retention, use, and disclosure restrictions for personal information. And primarily those are retention, use, and disclosure restrictions of PI specifically for the purposes of effectuating the service contract. Now, practically, what does all this mean? I need to ensure that I have a written contract with my service providers. And many of you, thinking of vendor service providers and contracts, it has your head swimming. Many of you might indeed have hundreds or even thousands of vendors that work within your organization, and how do you prioritize reviewing which vendors have PI, and then which vendors must first kind of be considered a service provider under the CCPA, because of their volume and risk. What we typically do with our clients is there's a number of little tips and tricks, because vendor service providers always have people in their head swimming. First of all, we'll look to slightly deviating GDPR contracts, because for the most part, even though the nomenclature is different, there are some few slight deviations that you can do within GDPR processes, and provided that those data flows are the same in Europe as they are in the United States. That's a big if. For many of you, you have completely different data flows in Europe and different systems in Europe than you have in the US. But if those systems are relatively the same, the nomenclature of the contracts isn't terribly different. As Larry said, you do have to do a deviation, but it's many of the provisions are indeed comparable. But if you have hundreds or thousands of these vendors, we would highly recommend things like security exhibits, things that you are slapping onto the back of the contract, thinking through security at the time that you want to uptake new services or undertake contractual renewals, so you have the leverage to do so. There are a lot of other tips and tricks to make this process manageable so it doesn't administratively overwhelm your organization. And as you are considering the topics of vendors, we would highly recommend that you classify vendors in terms of risk and deal with vendors on the basis of risk, because many of you are going to be getting into compliance, especially with the vendor provisions, for a number of years. And if you do have a data breach or an issue, it's helpful to be able to show the narrative that you are in the process of getting all your vendors compliant, and you are choosing to renegotiate those vendors in accordance with risk, and this vendor did not have as much data as others. So having a classification process, so you're keeping your vendor contract management and vendor due diligence manageable, in addition to satisfying the CCPA requirements. All right. And then I will pass this on, I believe, to David for the privacy policy update.
Back to David. That's right. Well, one other thing I would mention about the vendor management and vendor relationship aspects of the CCPA, and this goes to also, Amy, what you were talking about, is the need to be thinking about how the role that vendors will need to play in rights fulfillment. How do we understand from a data inventory perspective what data assets are with our vendor population, right? And which vendors are perhaps like self-service as we think about access to data, but data portability may be challenging with vendors. And we also may need our service provider partners to take affirmative actions on our behalf. And that, to me, that's a real nuts and bolts material, and it's really, really challenging, but it fits right into your point, too, about contractual commitments from vendors. So let's talk about two other focused issues that we're seeing come up that are not maybe, well, at least this issue, not one of the headlines, but it's something we want to be considering as we're working through our readiness program. First, talking about mandatory adjustments to our privacy policies. California has given us specific words that we need to put into our privacy policies, at least in terms of how we describe personal information, by reference to the definition that the CCA gives us. The standards for what we need to address in our privacy notices can be found in subsection 130A5. We effectively have a checklist. We need to provide information about the new rights that consumers have under the statute. We need to identify categories of personal information that we collect, that we sell, and that we transfer to third parties for a business purpose. When we define when we list the personal information that we collect and sell and transfer for a business purpose, we need to do that by reference to the definition of personal information found in the law. the challenge that can create is that California doesn't necessarily describe personal information the same way we all do in our existing privacy notices. That means that we likely are thinking about an update that perhaps expands our existing section on California privacy rights in our privacy policy rather than a general update to the policy. We might also include this content in an addendum. When we add the content, we need to map it carefully then to our existing representations. And if that requires a change in our policy, we need to go through a material change analysis from an FTC perspective to determine whether we need to provide conspicuous notice of the changes or perhaps, to take other steps that are required in the event of a material change. But what we're seeing is that most are looking at putting this new privacy policy content into a dedicated section or an addendum rather than updating the main body of the privacy policy because of the specific words that California would like us to use. The other issue we see coming up is the 12-month look back. This is a requirement to disclose data collection, sale, and transfer activities within the preceding 12 months. The policy behind this originally was to provide some type of an out date, right? So that we don't need to go back 10 years and talk about data sales, but rather it's only going back 12 months. But it's caused some challenges as companies think through what are we going to make our policy look like on day one, whenever it is that we deploy the policy, and do we need to be tracking data sales, data collection today to identify these activities in our new notice. There's an interesting consideration in that we have the 12-month look back and then a mandatory obligation to update the policy annually. So we have this potentially staggered tracking of we need to update within the preceding 12 months. Does that map specifically to a calendar year or to some other measurement period? But these are all factors just to consider and think about as we're taking this additional step. The upshot here is we can't wait until Q4. We should be working on thinking through our privacy policy activities either now or as we get to the end of the third quarter. Next, I'd like to talk about the definition of sell under the statute. There's been significant commentary on the definition in that it refers not just to transfers of data for monetary value, but also for other transfers that are backed by valuable consideration. And the general commentary you see is that this is a very broad definition, that it's expanded what we might otherwise think of as a sale. And, I don't know that that's the case. From the legal perspective. From the business, it might be a bit different from what we think, but I think as privacy practitioners, the broader definition is an opportunity for us to establish the business case, to take care to do a careful inventory of our data sharing arrangements, to root out sales that we wouldn't otherwise expect to exist. There's this, as noted here, reflective answer we will get sometimes from clients that we don't sell data. And that may be the common approach or policy within a company. But that's not enough from a CCPA perspective, and we have to be careful to challenge and diligence that conclusion appropriately in working with our internal business partners, but to ensure that we're not creating risk by failing to uncover stones or turn over stones. The other thing I mentioned about, again, just kind of quick points as we're thinking about this issue too and the definition of sale, is where we find transactions that could qualify as a data sale. Many companies, a number of companies we're working with, are okay with that. They're taking a position that we do sell data. We want to continue to retain that right in our information assets. So we're okay with placing a link in our digital properties. We're okay with establishing a mechanism to fulfill opt-out requests. But a number of other organizations are, absolutely not okay and do not want to put that on company.com that they sell data, and also don't want to be thinking about whether by disclosing data sales in our privacy policy, which maybe we don't today, we're making a material change, which is driving additional activities concerning level of notice and perhaps consent. In that case, we should think carefully and perhaps creatively about whether we can restructure data sharing arrangements in a way to remove them from the definition of a sale. The focus we have is primarily on the carve-out for consumer-directed transfers, and are we able to recast a data sharing arrangement in that way legitimately. The other would be whether we can address the activity with a provider that perhaps has overbroad rights in our data to fit that provider within the service provider definition that Amy was illustrating for us. So we've covered a fair amount of ground. I do want to take, and we've done it quickly, I do want to take a few minutes to go through some questions that the audience has provided, some real zingers. I'm going to try to give, yes. First, I must give our New York participants their CLE code, 061219. That's 061219. And now we'll get to the zingers. So I'm going to try to zing Larry and Amy. This is a great question and one that requires a fair amount of detail. So one participant asked a question about data sales with respect to cookies and other tracking technologies online and on digital, generally, I would say. So the question is, how does a business understand what third-party cookies they are collecting and the activities of those cookies? And Amy, do you want to take a crack at that? Of course, there are tools that can give insights, but then I know you'll have some thoughts, I'm sure, in more detail about how to think through this question. Amy, are you out there? You may be on mute.
I am. Of course, I said brilliant things on mute. No, I'm joking.
Know. Right.
But it is always difficult to track what your marketing teams and what your IT teams are doing with cookies on your website. David is right that there are tools like Ghostery that can help you inventory cookies as they are presented to you in your geographic location. I say that very specifically because as a company, someone who's in California may see a very different cookie set than someone who is in New York versus someone who is in Europe. So those inventory or cookie presentment tools like Ghostery should be used in conjunction with interviews of your marketing and IT teams and literally inventorying every cookie that has the right to attach to your web platform. And many of you had to already do this to create your cookie policies even before the GDPR was enacted. So, while this would be difficult, it's most certainly doable. And if you run across providers that people forget what that particular provider does, Ghostery also has an inventory of the different types of cookies available and the pieces of data that they typically collect, which is really helpful.
Great, great, and it's again an area that is a challenge thinking about our interrelationship with analytics providers in our digital environments and how that impacts potentially or comes within the scope potentially of the definition of a data sale. So it is a challenging area. Another question we received was with respect to the Nevada statute, and it's a question that talks about the different treatment that Nevada gives to organizations that are subject to HIPAA in contrast to the CCPA's application to PHI and medical information in use with respect by covered entities, business associates, or providers under the California, or the Confidentiality and Medical Information Act in California. So the question here is, how do we, is it correct to assume that the law will not apply to covered entities and business associates, even with respect to non-PHI data that they collect? And this is the Nevada statute. The answer right now is that it's, unfortunately, it's not clear. I agree that that's a good textual interpretation of the law, but I suspect that that's not the legislative intent. And so I think, there's a lot of detail to that question, but my initial inclination would be to think probably more narrowly about the application of that exemption, unless they had additional guidance from within Nevada in terms of the intent and the scope of the exemption. One other question that we'll address here, and that is, so we have a question about, let's see, the vendor relationship and what else is permitted in terms of a service provider's ability to use personal data not in connection with a specified service. So it's a great question in that the attendee asking it is quoting some specific parts of the statute about the fact that the definition of service provider permits use as otherwise permitted by this title, meaning the CCPA, and permits use for a commercial purpose other than providing the services specific in the contract. So I guess the question then is, can a vendor use data outside the scope of the delivery of the service and still be considered a service provider? Amy, do you have some thoughts on that question?
Absolutely. I hate that otherwise language within the contract. But what we believe is it's a generic reference, to other permissible purposes within the statute, like, compliance with federal statutes, compliance with a subpoena, a regulatory inquiry, cooperation with law enforcement, to exercise or defend your legal claims, and then also to collect, retain, sell, or use information in the aggregate. So, unfortunately, I wish that exception was a little bit broader, but it's limited to some rather narrow and also rather typical exclusions under this statute and others.
And I think, too, the further reference to use for a commercial purpose other than providing the services specified in the contract, I think that may be read to modify the restrictive clause and not the permissive clause. So we might say they may not use for any purpose other than for the specific purpose, including retaining, using, or disclosing for a commercial purpose. So I don't know that part of the clause expands the definition either. Well, we are at 2 o'clock Eastern, and I think we'll go ahead and wrap up. We do have a few additional questions that have been asked. We'll go ahead and provide answers to attendees. We'll follow also with an email with a copy of the slides, and a copy of the presentation will also be in audio form on alstonprivacy.com. Thank you, everyone, for attending.
And that concludes today's conference. Thank you for your participation.